Imagine you're in the middle of a legal fight. You've given the court evidence, detailed reports, maybe sworn statements, explaining exactly how something is impacting you.
Yeah, the kind of stuff you have to provide in court.
Exactly. Then you find out the other side has taken that precise evidence, stuff produced only for the court, and they're using it for something completely different.
Something like, say, lobbying the government to change the actual law in their favor.
Specifically to undermine your lawsuit. It sounds pretty wild.
And imagine that lobbying actually works. Like, bam, legislation gets introduced, passed almost overnight.
And designed to retrospectively shield them from the very thing you're suing about. Your own words, twisted to build a legislative wall against you.
Sounds like fiction, maybe a legal thriller.
You'd think so, but this is a real case. It happened in Australia. It involved ordinary residents, a really famous amusement park, corporate executives.
And it forced a deep dive into this fundamental legal idea called the implied undertaking.
And you, our listener, brought us the source material on this one, Hearne v. Street. It's absolutely fascinating.
So today, that's exactly what we're diving into.
Okay, so our mission here is to really unpack this legal drama. We want to identify the key players, the people involved, sure, but also the lawyers, the barristers, the judges navigating it all.
Right. Trace its path step by step. It went all the way up, didn't it?
It did. From the initial complaint through the appeals, right to the High Court of Australia. And we need to figure out how this one case really shifted things, how it fundamentally changed legal practice down under, especially around handling information shared in court.
Okay, let's set the scene then. Where did it all begin?
It started, maybe surprisingly, as a neighborhood dispute in Sydney. You had a group of residents living near Luna Park, Sydney. People like Jones Street and Mrs. Hess were named in the sources.
And they were suing the park, Luna Park Sydney, Tele Ltd., and another party too, over noise nuisance.
It's that classic noisy neighbor problem, isn't it? Just, massively scaled up because your neighbor is a huge amusement park.
Right, not just a stereo playing too loud. So this noise fight, it kicked off in the equity division of the NSW Supreme Court.
And like in most court cases, standard procedure, both sides have to exchange documents, discovery, affidavits, expert reports.
Yeah, the usual process. And this is where it gets critical for the later drama. Mrs. Hess, one of the residents, she swore an affidavit detailing her personal experiences, what the noise was actually like for her. And Dr. Tonin prepared an expert report for the residents, backing up their complaints with, technical data on the noise levels.
Right, okay, so these documents have the residents' core evidence, generated specifically for that court case, right?
Exactly, for the court's eyes only, essentially, under the rules.
So residents file their evidence. Now, here's where the story takes, a really sharp turn. We need to bring in some corporate players from the other side.
Okay, who are we talking about?
Peter Hearne, he was the managing director and CEO of Luna Park Sydney. And David Tierney, who was a strategic advisor for Multiplex.
Multiplex being the ultimate holding company for one of the defendants in that noise case.
That's the one. Now, Hearne and Tierney, instead of just dealing with these documents within the lawsuit,
they decided to use them somewhere else entirely.
Yeah, for what the courts later called a collateral purpose, something completely separate from the litigation itself.
And what was this collateral purpose? It wasn't just, incidental.
Oh, no, it was very explicit. Their goal was to lobby the New South Wales government. They wanted legislation passed that would basically protect Luna Park from these kinds of noise complaints.
Wow. So using the residents' own evidence against them politically.
Precisely. The sources tell us on July 25th, 2005, Mr. Hearne actually emailed extracts from Mrs. Hess's affidavit and Dr. Tonin's report directly to the Minister for Tourism, Sport, and Recreation.
Extracts from court documents sent straight to a government minister.
Yep. And then Mr. Tierney forwarded that email on October 13th, 2005. And get this, our sources even note that Tierney himself flagged it, mentioning it could potentially be contempt.
He knew it was dodgy, or at least questionable.
Seems like it. But despite that awareness, the lobbying push was, incredibly effective.
Yeah.
And incredibly fast.
How fast are we talking?
Astonishingly fast. The Luna Parkside Amendment Noise Control Bill, 2005, it was introduced into Parliament, debated, passed, and got royal assent, becoming law, all within about a week.
A week? That's lightning speed for legislation.
Right. And crucially, it was made retrospective. It applied backwards in time.
Which means it directly hit the residents' ongoing noise case.
Exactly. It essentially forced them to completely rethink and reframe their arguments. Their own evidence, taken from the court file, helped create a law that directly hindered their lawsuit.
That's a pretty stunning turn of events, isn't it? Just jaw-dropping.
It really is. And that brings us to the next act in this legal drama, the residents' response. What do you do then?
Well, they didn't just roll over and accept the new law and tweak their noise case. They did something much more significant.
What was that?
They started separate proceedings for contempt of court. And here's the key thing. They didn't just target the company, Luna Park Sydney.
They went after Hearne and Tierney personally.
Personally, aiming for individual accountability. That was a massive decision.
And we should probably mention the legal teams here because consistency matters in long cases like this. The residents, throughout this whole saga noise case, contempt, appeals, they were represented by the same firm.
Wise Legal, right?
Wise Legal Solicitors, yes. And their counsel were Mr. T.A. Alexis S.C. Senior Counsel and Mrs. P.M. Sibtain. That's a remarkable consistency over years of litigation.
It really shows commitment. On the other side, for Luna Park Sydney in the original noise case, the solicitors were Clayton Utz.
Okay. So when the residents launched the contempt action, Wise Legal wrote to Clayton Utz, alleging Hearne and Tierney were in contempt.
And Clayton Utz's initial response was interesting. They first said they didn't actually act for Hearne and Tierney personally on this.
Hedging their bets a bit.
Seems like it. And they offered only a qualified apology from LPS, the company, for any such contempt it may have committed. Emphasis on they may have.
That sounds weak. A qualified corporate apology. I can see why the residents wouldn't be satisfied with that.
Absolutely not. They were pushing for Hearne and Tierney, the individuals who sent the emails, to be held responsible. Eventually, Clayton Utz did confirm they were acting for Hearne and Tierney personally in the contempt proceedings.
And who were their counsel at the appeal stage?
For Hearne and Tierney, the Court of Appeal, counsel were Mr. T.G.R. Parker, S.C., and Mr. M.H. Baird. And there's a little side note in our sources. Apparently, Mr. Parker, S.C. had, on a previous occasion, made an apology to Justice Brereton on behalf of LPS, the company, about an earlier separate incident involving misuse of documents.
Really? So there was maybe some history there.
It certainly adds a layer, doesn't it?
Yeah.
Might explain why the residents were so determined to pursue personal liability this time around.
Makes sense. So the core charge against both Hearne and Tierney was the same thing.
Yes, that they breached the implied undertaking owed to the court.
Okay, let's pause there. This implied undertaking, it's clearly central. What exactly is it? Can you break that down?
Sure. It's a really fundamental legal rule, actually.
Right.
Basically, whenever you get documents because of a court process, like through discovery, or if they're attached to an affidavit like Mrs. Hess's, or produced under subpoena,
Okay.
there's an automatic implied promise, well, more than a promise, as we'll see, that you will only use those documents and the information in them for the purpose of that specific court case.
So only for the lawsuit they came from.
Exactly. You absolutely cannot use them for unrelated or collateral purposes.
Meant lobbying the government.
Precisely. Or, leaking them to the media, using them against a competitor in business, anything outside the scope of the litigation, that's the breach.
Got it. So the resident said Hearne and Tierney breached this by using the affidavit and report extracts for lobbying, which brings us to the first actual court decision on this contempt application.
Right. This landed before Justice Gazelle in the NSW Supreme Court. He heard the resident's case asking for Hearne and Tierney to be found guilty of contempt.
And what happened?
His Honor dismissed the charges against them.
Dismissed after all that. Why?
His reasoning turned entirely on who he thought was bound by this implied undertaking. Justice Gazelle found that, yeah, sure, Luna Park Sydney, the company, was bound. And its lawyers, Clayton Utz, they were bound.
But
Mr. Hearne and Mr. Tierney personally were not. He said it quite clearly, something like, there is no evidence that Mr. Hearne gave any undertaking to the court. The implied undertaking was that of Luna Park Sydney and its solicitors.
So he saw it as only binding the official party to the case and their lawyers, not the individual employees or officers acting for the company.
Exactly. He viewed it very narrowly. He didn't think the obligation extended to them as individuals.
That feels counterintuitive, maybe, if you're the one handling the documents for the company.
It does seem that way, and it became a huge point of contention later on appeal. Justice Gazelle also focused on knowledge. He wasn't satisfied they knew about the specific legal rule, the term implied undertaking.
Even though Tierney had flagged potential contempt.
Well, Gazelle J accepted Tierney knew the documents were, discovered or produced for the court case. But he thought that wasn't enough. He concluded their lack of knowledge of the specific undertaking itself meant they weren't liable for breaching it.
A very strict interpretation of knowledge.
Very. So obviously the residents weren't happy with that outcome. They appealed Justice Gazelle's dismissal.
Which takes us up a level to the NSW Court of Appeal. Same legal teams again.
Pretty much. Wise Legal with Mr. Alexis S.C. and Ms. Subtain for the residents. Clayton Nuts with Mr. Parker S.C. and Mr. Baird for Hearne, Tierney.
And the judges of the Court of Appeal?
The bench was composed of 3 justices of appeal, Ip J.A., Baston J.A., and Hanley A.J.A. And they immediately hit a major roadblock, a legal technicality.
Oh, was that?
It was about whether the residents could even appeal the dismissal, the competency of the appeal itself.
Why would they not be able to appeal a dismissal?
Well, it boils down to a tricky distinction in NSW law, specifically Section 101 of the Supreme Court Act. Basically, you generally can't appeal if someone is acquitted, found not guilty of what's called criminal contempt.
Okay.
But you can appeal an acquittal for civil contempt. So the very first question for the Court of Appeal was, what type of contempt are we dealing with here? Was misusing these court documents civil or criminal in nature?
Wow, so the label really mattered. It determined if the appeal could even go ahead. How did the judges see it?
Well, they didn't all agree, which shows how complex it was.
Okay.
Justice Hanley, AJA, he was in dissent on this point. He thought it was criminal contempt. His reasoning was that the main goal seemed punitive. The lobbying was done, the law was already changed, the company had even apologized for some earlier conduct. So he felt the residents' action now was mostly about punishing Hearne and Tierney for past behavior. And punishment points towards criminal contempt.
So in his view, the appeal was incompetent. It shouldn't even be heard.
That was his view, yes. No appeal allowed.
But he was in the minority.
He was. The majority, Justices Ip J.A. and Basson J.A., they reached the opposite conclusion. They decided it was civil contempt.
And their reasoning, how did they see it differently?
They looked at the purpose differently. They saw the contempt proceedings as being aimed at enforcing a legal obligation that implied undertaking primarily for the benefit of the residents, who were litigants in the ongoing noise case, and also, crucially, to protect the court's own processes from being abused.
So more about upholding the rules and protecting the parties involved rather than just punishment.
Exactly. They viewed the purpose as remedial, or maybe coercive, trying to deter future breaches by Hearne and Tierney, especially since the main noise case was still live, protecting the residents' privacy regarding their evidence, preventing further misuse.
That makes sense. Did they elaborate?
Yeah, IPJA specifically mentioned there was a reasonable possibility of future misuse, given what had already happened, and the fact Hearne and Tierney hadn't personally apologized or given any promises not to do it again. And Basson J.A. agreed, focusing more on the nature of the conduct itself. It was a breach of an undertaking that arises specifically within civil proceedings. So civil contempt seemed the better fit.
Okay, so the majority says, yes, it's civil contempt, therefore the appeal is competent, they can hear it.
Precisely. That hurdle cleared, the majority could then get to the main event. The substantive question: were Hearne and Tierney personally bound by the implied undertaking, and did they actually breach it?
And on this, they disagreed with Justice Gazelle.
Fundamentally. The majority held, yes, they were personally bound. They rejected Gazelle J's narrow view that the undertaking only stuck to the company and its lawyers.
How did they define the undertaking then?
They said it's not some kind of voluntary promise you imply from someone's actions. No, it's a substantive legal obligation imposed by law. It's a rule the law itself creates to make sure its processes aren't abused.
So it's automatic. The law imposes it whether you agree or not.
That's the key insight. And because it's imposed by law, they said this obligation extends beyond just the named party and their solicitors. It applies to anyone, employees, agents, directors like Hearne and Tierney, who gets hold of court documents through the court process and then uses them for a collateral purpose.
So their liability is direct, not just for helping the company breach it.
Direct personal liability. That was the crucial finding.
Okay, what about the knowledge point? Justice Gazelle said they didn't know the term implied undertaking. Did the Court of Appeal agree that mattered?
No, they clarified that too. You don't need to know the specific legal jargon, the label implied undertaking. What you do need to know are the facts that trigger the obligation.
Meaning,
you need to know that the documents you're using came from and were produced for the court proceedings. If you know that factual origin, the legal obligation attaches.
And did they find Hearne and Tierney knew that?
Justice Ip J.A. found it was proven beyond reasonable doubt for both of them. They clearly knew these documents were part of the litigation.
So the outcome at the Court of Appeal was a complete turnaround from Justice Gazelle.
Complete reversal.
Yeah.
The majority overturned Gazelle J's dismissal. They found Hearne and Tierney guilty of contempt on that first charge, misusing the documents. The case was then sent back down to Justice Gazelle to figure out the penalty.
Wow. A huge win for the residents and Wise Legal.
Absolutely. And just quickly remember, Justice Handley, AJA, the dissenter, he also disagreed with the majority on liability, sticking with Gazelle J's view. But he also flagged another interesting point.
Who was that?
He raised the issue of parliamentary privilege. He suggested that communications made to a minister trying to get legislation changed might be protected by privilege, raising what he termed a real question about whether that could be a defense to contempt.
Ah, interesting. The idea that lobbying Parliament might be specially protected, even if it involves using court documents.
Exactly. A potential conflict between the courts protecting their process and the legislature's sphere. But that wasn't the majority view.
So, Hearne and Tierney found guilty by the Court of Appeal. What happens next? They surely didn't leave it there.
No, they took it to the final stop. The High Court of Australia, the highest court in the land.
Another appeal. Who were the lawyers this time? Any changes?
Well, Clayton Utz were still the solicitors for Hearne and Tierney, but their lead counsel at the High Court was Mr. D.F. Jackson, QC Queen's Counsel. He'd actually appeared for LPS back in the original noise proceedings. Mr. Parker SC was also still involved.
Okay. And for the residents?
Still Wise Legal, still Mr. Alexis SC, still Miss Sibtain. Incredible consistency.
Right. And the High Court bench. Who heard this final appeal?
It was a full bench, 5 justices, Chief Justice Gleeson, and Justices Kirby, Hearne, Hayden, and Crennan.
The top court. And the final decision.
On August 6, 2008, the High Court delivered his judgment. Unanimously, they dismissed Hearne and Tierney's appeal.
Unanimous. So they upheld the Court of Appeal's decision finding them guilty.
They did. They confirmed the NSW Court of Appeal majority was correct.
What was the High Court's core reasoning? Did they add anything new?
The joint judgment from Justices Hearne, Hayden, and Crennan, with Chief Justice Gleeson just saying he agreed, really cemented the Court of Appeal's key points. They stated unequivocally, the implied undertaking is a substantive legal obligation that arises by operation of law.
Not an implied promise, but a legal rule.
Definitely a rule. Not something you choose to agree to, it just applies because of the situation getting documents via court process.
And did they agree it binds individuals directly, the Hearnes and Tierneys of the corporate world?
Yes. That was absolutely critical. They confirmed this legal obligation directly binds individuals, servants, agents, officers of corporate parties, who knowingly use those court-originating documents for a collateral purpose.
Their liability is direct and personal.
Direct and personal. It's not just about assisting the company to breach its undertaking. No, the obligation attaches to the individual who knows the document's origin and misuses it. They commit contempt in their own right.
That's a really important clarification for anyone working within a company involved in litigation.
Huge. And on the knowledge point.
Did they stick with the Court of Appeal view? That you only need to know the facts, not the legal rule name.
Correct. The High Court reinforced that. Knowledge of the facts that the documents came from the court proceedings is what triggers the obligation. Ignorance of the specific legal rule, the implied undertaking, is no excuse. It's a classic, ignorance of the law is no defense situation.
And it wasn't really disputed that Hearne and Tierney knew where the documents came from, was it?
No, that factual knowledge wasn't seriously challenged. They knew the affidavit and report were part of the litigation.
Okay, so that seems incredibly definitive from the highest court. Individuals are personally on the hook if they misuse court documents they know came from the process. End of story.
That's certainly the core legal principle solidified by the High Court majority, yes. However, it's always worth looking at concurring judgments. Justice Kirby agreed with the final outcome, dismissing the appeal, but he wrote separately to express some, well, unease.
Unease. About what? He agreed they were guilty.
He did agree on the application of the law as it was argued, but he felt the case had been decided on quite narrow grounds, based only on the specific arguments the parties chose to run.
And he thought there were bigger issues lurking.
Exactly. He highlighted what he saw as significant unresolved questions that hadn't really been debated by the parties, particularly that tension we mentioned earlier.
The parliamentary privilege point.
Yes. The potential clash between the court's power to punish contempt and the principle of parliamentary privilege, especially when the misuse involves lobbying ministers or parliament for legislative change.
So the same concern Justice Handley, AJA, raised in the court below.
Precisely. Justice Kirby pointed to the important constitutional right people have to petition Parliament and the executive government. He worried that the interaction between that right and the court's contempt power when the petition uses court documents hadn't been really explored or resolved in this case.
So while he agreed the implied undertaking rule applied as argued, he felt a deeper constitutional question about lobbying and privilege was sort of left hanging.
That's the gist of his unease, a significant point, even if it didn't change the outcome here.
Okay, so let's zoom out. We've gone from a noise complaint all the way to the High Court. What's the legacy here? How did Hearne v. Street actually change legal practice in Australia?
Oh, it had a really significant impact.
Yeah.
I mean, first, it took that implied undertaking and absolutely cemented its status. It's not some vague, fuzzy understanding. It's a hard-edged, substantive legal obligation imposed by the law itself. That elevates its importance considerably.
Okay, that's the nature of the rule. What else?
Perhaps the most crucial practical impact was settling the question of personal liability. The High Court made it crystal clear. This obligation imposes direct personal liability on the individuals inside companies, the officers, the employees, the agents, if they misuse litigation documents.
Provided they know the documents came from court proceedings.
That's the key qualifier, yes. If they have that factual knowledge, they can be held personally accountable for contempt. The corporate structure doesn't shield them from this obligation. You can't just say the company did it if you were the individual who misused the document.
That must have sent ripples through legal departments and boardrooms.
Absolutely.
Yeah.
Think about the practical implications. For lawyers, Hearne v. Street really hammered home the duty to advise clients much more carefully.
How so?
You can't just advise the company anymore. Lawyers now have a very clear responsibility to rigorously warn the individuals within the client organization, directors, senior managers, key staff involved in the case, about these strict rules on using court documents.
And about the personal risks.
And about the very real risk of personal liability for contempt if they breach those rules. It's a direct warning. You personally could be in trouble.
And for the corporations themselves, what changed internally?
Well, Hearne v. Street basically forced corporations to get serious about internal controls. They needed to implement robust protocols for handling litigation documents, clear procedures, training for staff.
To stop employees using sensitive court materials for anything outside the actual lawsuit, like lobbying or talking to the press or competitor analysis.
Exactly. Because the case showed that just relying on the company potentially being liable wasn't enough protection. Individuals were clearly on the hook now.
And for those senior managers and directors, the Hearnes and Tierney's?
For them, it was a huge wake-up call. The decisions starkly underline the significant personal risks they face. Being found in contempt personally isn't trivial. It can mean hefty fines, massive legal costs, orders against you personally, reputational damage, and in theory, even more severe penalties in some circumstances.
So it's a clear message. Your personal actions and judgment regarding court documents has serious consequences that go beyond just the company's liability.
Absolutely. The corporate veil doesn't protect you from this particular obligation.
So, looking at the bigger picture, the case really reinforced the court's power and determination to protect its own processes, didn't it?
It did. It sent a strong signal. You can't use the court's own machinery, its power, to compel document production to get information and then turn around and use that very information to try and manipulate the legal or political landscape against the other party or undermine the court process itself.
Even if your goal is lobbying for what you see as necessary legislative change.
Even then, it's a powerful assertion of the court's authority to prevent its processes from being abused or instrumentalized, even when it gets tangled up with political activity.
And what a journey we've traced, thanks to the sources you brought us. Started with a local noise dispute.
Then plunged into complex legal arguments in the NSW Supreme Court and Court of Appeal about the very nature of contempt, who the undertaking binds. Was it civil? Was it criminal?
All culminating in this unanimous landmark high court decision that clarified these fundamental legal obligations and locked in that principle of direct personal liability for individuals.
Yeah, you brought us the material, and look at the layers we've uncovered. It's a real legal drama, corporate action, individual accountability put under the microscope, legal principles tested and refined at every level of the Australian court system.
It really shows how these sometimes seemingly technical legal concepts can have incredibly real personal impacts and consequences.
Definitely. But even with that definitive high court ruling on the implied undertaking and personal liability, remember Justice Kirby's unease.
Right, echoing Justice Hanley AJA's point from the court below.
They both flagged that potentially unresolved tension, didn't they? Between parliamentary privilege, the right to petition your government, and the court's power to punish contempt when court documents are used in that petitioning process.
Where does that line really sit? Between legitimately asking the government to change the law and improperly interfering with the administration of justice by misusing documents you only got because of a court order.
It's a fascinating question, isn't it? This case brought it sharply into focus, but as Kirby suggested, maybe didn't fully settle it,
Leaving it perhaps for another case, another future legal drama to resolve.
which is often how the common law evolves, right? Landmark cases settle key points, but can also surface new, complex questions for down the track.
A great reminder of that. Well, thanks for joining us on this deep dive.